Hi, welcome to Boorman Lawyers. Today we are going to look at a low-range drink driving offence that we appeared on at the Caloundra Magistrates Court on the Sunshine Coast in Queensland.
G'day, welcome to Boorman Lawyers. It's Josh Boorman here. I'm just standing outside the Caloundra Magistrates Court where I've just come out of a low-range drink driving matter. Basically what happened today is we appeared on sentence. My client had previously been charged driving out in Western Queensland in the rural town of Charleville. The matter was set before the Charleville Magistrates Court. However, we were able to have the matter transferred closer to where my client lives here around Caloundra. So we appeared here today and we plead for the maximum amount of leniency. Our client had been charged with a low-range drink driving offence, or as they call it, a drive over the general limit but under the middle range limit. The penalties involved were anywhere between 1 month to 9 months off the road for a disqualification and anywhere up to a $1,649 fine. So we were pleading for leniency, and we explained we needed to present the case to the court to try and get that maximum amount of leniency. We were able to show the court that this was a next day type of offence where our client still had remnants or traces of alcohol in his system after drinking alcohol from the night before. So it occurred, he was pulled over by police at 9:30 the next morning and still had a blood alcohol limit of 0.075. We were able to also tender medical evidence to show that our client does have a poor liver function, which, whilst it doesn't mean the alcohol is not in his system, or the blood alcohol reading is not representative of the alcohol in his system, we were able to show that having a poor liver function can take it a long time or a longer period of time for alcohol to metabolize out of the body. So we were able to get these medical reports and prove this to the court and show the court that our client was previously unaware of the fact that he did have a poor liver function, and that from now and into the future he needs to be more vigilant and more conscious of the fact that due to his poor health, he does need to leave a lot longer period of time for alcohol to be removed from his system. So this was obviously, it wasn't used as an excuse, but certainly a bit of insight and reasoning behind why our client thought he may have been right to drive and thought he was under the limit some 12-13 hours after he'd consumed his last drink, and the next day after going to sleep and waking up and thinking he was right to drive. Our client had a relatively good traffic history for someone who has spent a lot of time on the road over the last 15-16 years driving for his work. Unfortunately, due to other medical issues that he has had to reluctantly resign from his job as of about 2 weeks ago, and since this incident occurred. So basically, unfortunately, this meant our client was precluded from applying for a Section 87 restricted work licence here in Queensland. So we were seeking the maximum amount of leniency in relation to fine and disqualification. The magistrate seemed very receptive to the submissions we put forward, in particular the issues we raised of how the actual offending behaviour was at the lower end of the offending scale, and also due to the fact that he had some medical issues which he's now aware of. Going forward, we were able to ask the court to provide the maximum level of leniency. The court agreed that it should be 1 month disqualification off the road starting from today, and the fine should be reduced down to an amount of $350. Our client was very happy with this. He was certainly nervous going into court, wasn't sure how it would all play out or how to best prepare for the case, but we handled all that side of it for him. We spoke on his behalf, and he was very happy with the outcome. So if you have been charged with any sort of drink drive, drug drive or major traffic offence in Queensland, feel free to give me a call on 1300 941 900, or you can go along to the website, which is BoormanLawyers.com.au. That's Boorman, Boorman, And there's a whole heap of information, blog posts, videos, statistics, charts, case studies on there about drink driving, drug driving and other traffic offences, and also criminal offences too in Queensland. Please note that we are based around Gold Coast and Brisbane, but we do travel to all of the courts around southeast Queensland and even the northern New South Wales. So we're certainly available and able to attend most of the courts in your area and assist you when your matter comes before the court. So thanks for tuning in, guys. If you need to find out a bit more information, please go along to our website, or again, feel free to call me 1300 941 900. Thanks for tuning in.